Thank you very much, Jenny, and welcome everyone. Also from my side, my name is Žiga Drobnic. It's a pleasure to be here with you today. I have joined the European Union Intellectual Property Office, which is located in Spain, last February, and I've been working in copyright for a while now. So I'll be giving you a bit of an overview on the impact of frontier technologies on intellectual property. First of all, I would just like to add this disclaimer that the views expressed are purely my view, and they don't represent the position of the European Intellectual Property Office. And of course, what I will be explaining to you is really streamlined to this presentation, and that it does not provide an exhaustive overview of either the work of the EUIPO or the EU legislative framework. So I will try to cover a lot of ground here. I'll briefly introduce the EUIPO and the Observatory of IP infringements. Then I'll give you examples of the use of IP technology at the EUIPO, but also what we come across in the context of IP infringements. I will also give you a brief overview of the EU copyright framework and other relevant legislation. And I'll finish with an example of the work we do in fighting live event piracy. So you will probably receive the slides at the end. There might be some information which I will not necessarily go into details or mention, but you will have the possibility to read it afterwards. So if before I start, let me just spill a bit the beans and give you my 3 takeaways already at the beginning. So new technologies pose new challenges for IP, but as also the introductory speaker explained, it's a double-edged sword. So we have user-fronted technologies both on the infringement and on the enforcement side. New regulations are building on cooperation, transparency. There is a multi-layered approach to obligations and to enforcement. And the new regulations are also balancing out different sides, and they bring more accountability requirements for the new players, which I will explain later on as well. And the new enforcement measures need to be fast, and they need to be flexible to adapt to the new situations and challenges posed by the developing users. So what are frontier technologies? I used the definition from the World Intellectual Property Office. So they are breakthrough technologies that change our lives, such as artificial intelligence, blockchain, 3D printing. You have digital ones, physical ones, biological ones. And I also wanted to say that according to the re-elected European Commission President, Ursula von der Leyen, it has also become one of the, or will remain one of the priorities for the next European Commission. So from our side, from the European Commission side and the agencies, you will probably hear a bit more about that also in the next years. What is the European Union Intellectual Property Office that I call EUIPO? So it's the EU agency which is responsible for managing the EU trademarks, the registered community designs, and since very recently also the geographical indications. Part of it is the European Observatory on Infringement of Intellectual Property Rights, which has been integrated into the EUIPO in 2012, and it has 3 goals, which explain a bit of the work we're doing. So the observatory provides facts and evidence to support policymaking. It creates tools to resources to help in the fight against IP infringement, and also raises awareness of IP on the negative effects of counterfeiting and piracy. But in practice, this means that we are working on various topics which relate to IP infringement. We're managing a network of experts and specialist stakeholders coming from the private, public, and civil society. We organize working groups, expert groups, and we also developed tools, which I mentioned before, such as the IP enforcement portal, which is a platform that allows the communication between rights holders on the one hand and enforcement authorities on the other, and also help in the management of customs applications for action. That may ring a bell with some of you who come from the enforcement side. So here I will talk about the possible applications of frontier technologies in the context of IP, and the EWIPO has a strong commitment to innovative technologies and has been also voted for the most innovative intellectual property office for the 5th time, not in a row. So sometimes we share it with others, but overall for the 5th time. And here I will present to you 2 examples to showcase the use of these technologies in our office. One is for trademark and design registrations, and the other one is for use of blockchain for the IP, intellectual property register. So here you can see at this slide the different steps for trademark registration, which will go from trademark applications, the different formalities, the examination of an absolute grounds, the translations, then if there is an opposition procedure, and at the end also the registration. So the following slide shows you the tools and services which are being the type of artificial intelligence uses that are being made, such as at the beginning the use of chatbots, image comparison, or suggesting for drafting decisions, for example, at the end. So this helps to make the entire registration procedure from the beginning to the end more efficient and also more precise. So it's less likely that there would be an error which would have to be then challenged later on. The following slide is also showing a showcase of the use of blockchain technology for the IP register. For both trademark and community design, the current system is centralized, with the EWIPO being responsible for the registry. And in this project, which is built on the nature of blockchain technology, it's that it's based on a decentralized system, which in this case is a closed one, and it's carried by the nodes of the participating offices, which provides for better security in case of cyber attacks, stability of the system, but as well as more efficiency, because the data transfer is, for example, in real time. But through our work at the observatory, we also come across uses of frontier technologies in the context of IP infringement, particularly AI. So here I will talk a lot about AI. For example, we have the observatory has run a study on artificial intelligence and infringement and enforcement of copyright and design. And there were several scenarios presented. In one of them, for example, the artificial intelligence systems offer opportunities for actors, for malicious actors, to enhance their attacks, exploit new victims, and create more and really innovative criminal business models. And among the possible uses were, for example, the use of AI-supported password guessing to hack databases, or the use of AI and machine learning to eliminate, for example, digital watermarks of copyright-protected works. It also offers new challenges in the IP context, such as the use of and protection of trademarks, design, copyright-protected works in the metaverse. There is also an ongoing debate on the use of copyright-protected works for AI training, which my colleague Lucia will explain a bit further. But it's a double-edged sword, which is something also that the introductory speaker mentioned. At the same time, this technology can also be used to create tools for enforcement. For example, in our work against fighting online piracy, we know that the Spanish sports organizer La Liga is using computer vision AI technology to monitor the video content on suspicious websites, and the tool detects illegal content, and then also generates automatic reports, which are pardon, which are sent in real time to the respective intermediaries asking for this illegal content to be removed. And in line with our commitment for new technologies and IP protection, we have also recently published an anti-counterfeiting and anti-piracy technology guide. Complicated word, ACAPT is the abbreviation. It's a repository of over 40 counterfeit and anti-piracy technologies, which can be found, for example, you can look for it for physical, for digital products, whether they should be used for, whether somebody is looking for them for the use of, for authentication, tracing, whether it should be invisible, visible. So the aim is that the producers of these technologies showcase their uses on the one hand, and that enterprises that wish to protect their IP rights know where to find them, where to find the right technology for their case. This is, for example, one of the, this is the landing page where you can see, you can look for electronic technologies, you can look for mechanical technologies, for example, fabricating labels, marking technologies, and so on. So now the second part, I'll give you a brief introduction to the EU framework relevant for copyright and online IP enforcement. You've already seen this slide. I would just like to clarify the terms that I will use, and then you may also hear later on. So vertical and horizontal legislative acts. Vertical applies to a specific sector, for example, copyright, while horizontals are cross-sectoral rules sitting on top. For example, Digital Services Act or digital services on the intermediaries. Directives and regulations are two of the most used type of legal acts in EU legislation. And the difference is that the regulation becomes immediately national law, and you have to keep in mind that the EU has 27 member states, so 27 different systems, while a directive provides rules which then need to be transposed into national legislation. So it's up to the 27 member states to make them international law, depending on the situation. And usually member states have 2 years, 2 years to do so. So I will touch upon a brief I will speak briefly about EU copyright, particularly the legislation which regulates direct liability. I will talk about the Digital Services Act, the AI Act, which was also mentioned, and also from an enforcement perspective, I will speak about the possibilities to obtain injunctions. So the body of the EU copyright, which in the jargon or slang, if you want it in the EU, is called Copyright Acquis, consists of 13 directives and 2 regulations. It has over the years harmonized the economic rights of authors, so copyright, but also the performers, producers and broadcasters, so the related rights, except for moral rights, because these are regulated at national level without any EU-wide harmonization, so they have not been adjusted. This is really up to the member states. And copyright registration at EU or national level is not required for to obtain protection. So let's have a look at the 2 most relevant copyright directives for the online environment. Here is the directive on copyright in the information society called InfoSoc from 2001, and the more recent copyright in the digital single market, which we call also DSM directive from 2019. So we have two directives here. The InfoSoc directive harmonized the exclusive rights exceptions, limitations, and provided for the possibility that right owners seek damage or injunctive relief or apply seizures for infringing material. The InfoSoc particularly harmonize the exclusive rights to so authorize or prohibit the use of exploitation of a work, especially the reproduction, communication to the public, or the making available to the public, as you can see, and the distribution. It also sets a number of exceptions and limitations to the rights. It's a closed list, and if this is to compare it to the fair use principle in the US, where it's an open list. Here, it's a closed list. Some exceptions are mandatory, and some are left optional for the member states to apply or not. But they are all under strict conditions, and they exist, for example, for teaching purposes, for visually impaired persons. I'm talking about the InfoSoc directive. This directive also sets the DSM directive then updated some of the existing provisions. It also introduced new ones. For example, it introduced a new provision to address what was identified as a value gap. So the fact that copyright protected content was available on platforms, generating revenues for example, video sharing platforms. But the rights holders did not really have any benefit from that or give their authorization. So this, it's Article 17 was aimed to address this issue. But for this debate, more importantly, it also introduced the text and data mining exception, or TDM, as you will hear. And my colleague will speak further on this topic after when I finish. Then, if we continue to the Digital Services Act, this one has also been adopted, as you can see, in 2022. It aims to prevent that it aims to prevent illegal and harmful content, and it sets also rules covering what we can call secondary liability, or to be more precise, it sets the exemptions from liability. It builds upon more older directive, the e-commerce directive from 2000 and from the year 2000. And that directive said that intermediary service providers should not be liable for the content they transmit, store, or host, as long as they act in a passive manner. So they need to have a neutral role. And the mere conduit, caching, and hosting categories are the ones that were, let's say, established by this e-commerce directive. The hosting providers are particularly relevant because the exemption from liability is conditioned that the provider, upon obtaining knowledge or awareness of the illegal activity or information, takes immediate action. For example, when they receive knowledge or awareness through a notification. And this was then further streamlined by the Digital Services Act. But the liability exemption cannot prevent a court order or administrative order, for example, through the directive, which I will mention later, IPRED, or from the just mentioned InfoSoc directive. And these orders can require the service to terminate or prevent an infringement immediately. But then the DSA also clarifies and rebalances a bit the responsibilities of providers of these intermediary services. For example, it codified what was accepted but not laid down in the e-commerce directive, because if you remember, it's from 2000. So 22 years later, the DSA was adopted. It accepted what in the US is called the Good Samaritan principle. So it added a new provision saying that intermediary services do not automatically become ineligible for the liability exemption if they carry out a voluntary investigation at their own initiative. So that does not make them, let's say, not immune. It's a bit complicated to explain. But basically, if they carry out voluntary investigations, they can still be exempted from liability. It also the DSA also added because in the meantime marketplaces came onto the landscape that liability exemptions do not apply to marketplaces when they make the consumer believe that whatever is on the marketplaces, so products, information, or the services provided, is provided by the platform itself or under its authority. Member states in general are prevented from imposing a general monitoring obligation on service providers. This is also a very important part. What is entirely new under the DSA is the new list of asymmetric, due diligence obligations, which are asymmetric because they are tailored to the service's size and the impact. The aim is to increase their accountability and transparency in their operations. So the bigger you are, the more obligations you will have. And in this context, it added 2 new categories that you can see on the under the plus sign. One is online platforms and very large online platforms and very large search engines. And providers of intermediate services that offer services in the European Union need to have either an establishment in the EU or a legal representative in one of the member states if they provide services in the EU. That is also very important. Now coming to the enforcement side, it's worth to note that the DSA put forward a multi-layered oversight structure. So the entire regulation will be enforced through national services coordinators at national level, but also the European Commission has a role here. And this whole structure will be supported is supported by an independent advisory group, which is called the European Board for Digital Services. This type of structure you will also see later at the with the Artificial Intelligence Act. So to continue about these asymmetric due diligence obligations, this graphic it should kind of visualize the different levels that lead to different obligations, starting from the intermediary services, for example, internet access providers, then hosting providers, online platforms. It's important to say that online platforms are hosting providers, so it's an upgrade of them. And they allow users to make content publicly available, for example, online marketplaces, social media platforms. These are all in this category. And at the end, very large platforms and very large search engines that reach at least 45 million users monthly. So what are these due diligence obligations? They're gradual and depend on the intermediary. So type and the size. For example, all intermediaries need to have a point of contact for recipients of the service or a legal representative in the EU. They need to regularly report on judicial and administrative orders or removals. This is conditioned by their size. Notice and action requirements apply only for, from hosting providers onwards. Online platforms need to have repeat infringing policies. The recipients of services also need to have access to an out-of-court settlement system. And very large platforms need to carry out, these are the ones that are targeted with most stringent requirements. They need to carry out a risk assessment and put in place mitigation measures. SMEs, well, there is an exemption for certain obligations, such as the Know Your Business Customer for online marketplaces, and also some transparency obligations. Now we come to the AI Act, which is the latest legislative act in this collection. It's, as was mentioned at the beginning, it's the first of its kind. It introduces a set of horizontal rules that provide AI developers and the deployers with clear requirements and obligations. It's based on a risk model, which then defines the level obligations depending on the risk, which is very much like the DSA that I mentioned before. And it has the sorry. And there is a certain also interaction with copyright, but I'd like to give you an overview first. So the as I mentioned, it's the first comprehensive legislative framework on AI. It was adopted recently after 3 years of negotiations between the co-legislators to arrive to final text. It sets a common framework for the use and supply of AI systems in the EU, and in principle it applies to all applications across all sectors. It's risk-based, so the higher the risk, the stricter the rules. The enforcement is ensured by national competent authorities and the AI office, so similar again to the DSA. The AI office will sit within the commission and will be tasked with overseeing the most advanced AI models, and will contribute to the development of new standards, testing practices, and enforcing the common rules in all 27 member states. The risk classifications based on the purpose for which AI systems are intended. And there is also an annex to the AI Act for use cases which are considered to be very high risk. It's worth a look. And the EU approach to artificial intelligence, which was also mentioned, is based on trust. So the AI Act promotes regulatory sandboxes, real-world testing to test AI before they're being put on the market. This slideshow shows this again, the hierarchy to the risk level of AI systems. So it depends really on the function performed by the AI system on the specific and on the specific purpose. They range from minimal on the bottom with no restrictions, then there are limited risks where the users should be informed that they are, for example, interacting with an AI chat box, that the output is AI generated. Then there's the higher risk, which is subject to strict obligations before they can be put on the market. For example, they have to make a risk assessment. And then there are also obviously those that propose an unacceptable risk and cannot be placed on the EU market. For example, when an AI system that can lead then to discrimination or the exclusion of certain groups. A special category, also the so-called general purpose AI models, or GPA-AI, which is a type of AI model that are trained on large data. They can perform various tasks and they can be integrated in other platforms. Foundation models, for example, generative AI models are a type of general purpose AI models. And there too, they can have systemic risk. For example, if a very powerful model could cause serious accidents, could be misused for far-reaching cyber attacks, or for example, for building bombs. You probably read about this as well in the news. What is relevant here is that there is this intersection with copyright that I mentioned before, and the AI Act introduced transparency obligations for general purpose AI actors. So they will have to adopt a policy to respect the reservations of rights under EU copyright. The provision provides that operators will need to respect European Union copyright law through a policy, and in particularly identify and respect the reservations of rights expressed through the TDM exception of the DSM directive, which I mentioned before, and which you will also hear more at the end. So what's also very interesting is that the explanatory part of the AI Act states that providers should adopt copyright policy regardless of the jurisdiction in which the training takes place. So no provider should be able to gain a competitive advantage in the EU market by applying lower copyright standards than those that are provided in the EU. It should also make a publicly sufficient detailed summary about the content which is used for training. It should be easy to understand, not too technically detailed, so that those that have interest, for example, rights holders, can easily exercise and enforce their rights, for example, through licensing. The templates for these detailed summaries will be provided by the AI office, which sits within the European Commission. And finally, which I also mentioned before, is that the output generated by AI should be clearly marked in a machine-readable way. So, as it's quite a comprehensive piece of legislation, the entering of the application is graduate. So as you can see, the prohibited systems, the rules on the prohibited systems will apply from February next year onwards. The relevant rules for general purpose AI models are being applicable as of August next year, so in 1 year. And all the other rules apply from August 2026. Here I'd like to stop a moment and draw your attention to what I already showed you a bit, that trend. So while the early legislation, we had the e-commerce directive in 2000 and the InfoSoc in 2001, which was a very different time with new players coming on the market. It placed much of the burden on rights holders, but with the development, with the importance of the role, the maturity of these new intermediaries and services, thinking about online marketplaces, content sharing platforms, generative AI applications, there was a rebalance of the burden, and these actors are now subject to more accountability and more stricter rules. And this can be traced, as I said, in the Digital Single Market with the Digital Services Act and the AI Act as well. Coming now to the last pillar, the green one, is on legislative measures, IP enforcement. I'll briefly talk about the IP Directive from 2004. It provides a minimum set of measures and procedures and remedies to allow for civil enforcement of IPR. So here I have to underline that it's civil, it's not criminal, because the competences of the EU in criminal matters are somehow limited, and so here it's in civil matters. It provides the rights holders or their authorized person the right to request for IP protection measures. Here is a bit of an overview, but what is relevant is that, amongst others, the directive has provisions on the possibility for courts to take actions. For example, injunctions, blocking injunctions which are addressed at intermediaries on existing infringement. For example, blocking a website because it offers streaming to illegal content, copyright protected content, or to a marketplace which offers counterfeit, which is majorly offers counterfeit products. They also offer the provisional and precautionary measures, so to prevent any impeding infringement of an intellectual property, meaning ahead of the actual infringement. This is very important, but I'll be mentioning later. And here I'd like to speak a bit more about the injunctions against intermediaries, which have been subject to two of our papers, the EUIPO. So one is a study on dynamic blocking injunctions, and last year's paper on live event piracy. So why is this important? It's because live events, for example, football matches, they have they have the exploitation value while they're happening. So during the live broadcast, which makes this type of piracy particularly damaging. So we have mentioned at the beginning that there are new performative technologies that can help IP infringers to put live piracy content online, avoid certain anti-piracy measures. But we've also seen that AI technologies are used to identify such content, request takedowns in real time. Now, the time window for enforcement action is very narrow, so it's usually the duration of this event. And on the next slides, we'll see how these challenges have been addressed by different national authorities who have the power to obviously enforce the rules. So there are, I'll just give you an overview. There are 3 types of blocking injunctions which can be issued depending on the situation and on the judicial system. So there are static, those that are targeting one internet location, for example, an IP address or a website. Then there are dynamic ones, which allow to extend the blocking order beyond its initially targeted location. So you can add new websites, new IP addresses. After a while, for example, if there was a diversion, if there was a mirroring of a website, offering IP infringing content. And then there are also live, which are targeted for a specific duration, really live events. There is no statutory definition, so no legal definition of dynamic and live blocking injunctions. And so the provisions have also been implemented with slight differences across the member states. We also have a landmark case by the highest court in the EU, which is responsible for EU legislation, the Court of Justice of the EU. And it says that injunctions need to be effective and proportionate, respect a fair balance between fundamental rights and interests, and do not involve a general monitoring obligation. Here, this might ring a bell. We already had this in the DSA and in the e-commerce directive. And so this is the framework where the national courts operate. The next slide shows some of the different practices that have developed in member states in relation to live blocking orders. So you can see that some countries have developed dynamic and live blocking injunctions. They are really targeting live events. In some countries, court orders are being updated by administrative authorities, for example, in France. Then you also have national administration that can issue administrative orders. So not the court. This is done in Italy, Greece, and Portugal. And then you also have voluntary agreements whereby an administrative authority is has the role of a trusted third party in between rights holders and internet service providers. And this is then happening in, for example, in Portugal. But so this shows that there are really different possibilities to tackle the issue. So, but hard law is not the only way. There are also intermediary steps, and here I'd like to mention the Commission, which has issued a non-legally binding recommendation on how to combat online piracy of sports and other live events last year. In May last year, it's addressed to member states, to rights holders, and to intermediaries, so these 3 groups, and it focuses on prompt treatment of notices, encouraging member states to use dynamic injunctions. Here you can see it is a possibility given by the IPRED directive. And here in this recommendation, it recommends member states to start applying, to change the legislation so that they can apply dynamic injunctions if they have not done that yet. It also takes the stance that commercial offers and awareness has also a role in fighting live event piracy, and cooperation among the 3 main addressees. So cooperation between member states, holders of rights, and intermediaries. That's also a way how to address challenges raised by these new technologies. The EUIPO and the observatory specifically were asked to support the Commission in monitoring the effects that this recommendation will have, because the Commission will issue a report in November next year, and then they will decide whether additional measures are needed, for example, if legislation is needed. And what we are doing is we're monitoring the effectiveness through a set of key performance indicators. So we send out templates to interested parties, and they return us numbers of notifications sent, numbers of cooperation agreements they have. This will help us and the Commission particularly in assessing the effectiveness of this recommendation. And we have also set up a dedicated network of national authorities that deal specifically with live event piracy or have responsibilities for piracy, so that they can exchange information taken by one, exchange information that what each member state has done, good practices, for example, on dynamic injunctions. So this also is helping in addressing these challenges. And then similarly, there was also a recommendation to combat counterfeiting, which was issued in March this year. It's again addressed to member states, rights holders, and intermediaries. And I'd just like to mention two of the key areas. They relate to adapting procedures to counter new counterfeiting practices, and also to adapt IP practices to AI and the virtual worlds. And the EUIPO again has the role to raise awareness of this, of these measures, to take to support the implementation and also help with the monitoring of the impact of this of the effects of this recommendation. So I'm coming towards the end of my presentation. I would like to just repeat my three key takeaways from the beginning. So new technologies pose new challenges for IP, but I said it is a double-edged sword because they can be used for infringement and for enforcement as well. The new regulations are building on cooperation, transparency. There is a new approach to obligations and enforcement, which is multi-layered, multi-layered for the actors, for the intermediaries, which have to, depending on their size, their impact, but also on the enforcement side. So the Commission also has a role more and more, and member states as well, and the cooperation among them is very important, so that there is a more accountability requirements for these new players. And as I said, the requirement, the enforcement measures need to be fast and flexible to adapt to new situations. So with this, I would like to stop my presentation. And I might have just a very quick, I see that there have been 3 questions. I'm sorry, because I will have to leave very, very there was a question whether copyright registration or deposit system will become obsolete because of the availability of blockchain technology to trace authenticate works. I personally think that it's not, I wouldn't say that they would become obsolete. In the EU, there is no copyright registration system, but there are some systems where you can, for example, timestamp your work. So in case there is a judicial procedure that you can, it helps made before. It's, I wouldn't say that it would become obsolete. It's going to be a very interesting debate what will happen now also with artificial intelligence. But blockchain is just one of the possibilities that there is on the market. As I said, the office is using blockchain for IP registration, for trademark and design. I think it complements, but there is no clear, let's say, no one solution fits it all. Okay, unfortunately I can't take any more questions, but I'm happy to reply to them later on if Jen then can forward them to me.